Hey everybody, it's about 8:46 here on Thursday evening. Thanks for joining in. It's been a long day. I got my buddy Buford's uh, t-shirt on today. If you haven't seen him over there in the Arcola area, stop in and see him. But there's been a few stories coming out on the Thornley matter, and I think they're worth you hearing about and understanding. And I want to make it clear, I don't know Mrs. Thornley. I don't hold any ill will towards her. She's been charged with a crime. She's presumed innocent till proven guilty. And, my interest in this case has more to do with what the government did in trying to cover it up, in my opinion, versus the allegations of the crimes against Miss Thornley. So I want to make that clear. But there was an article that was done today by Greg Bishop from the Center Square that started me off on a path. And the article here, Ryan has just pulled up. If you haven't had a chance to look at it, you should. But let's look at the caption. Attorney General says Pritzker connected work comp fraud case referred to appellate prosecutor. Scroll down to about the third paragraph, Ryan. I want to read the quote that Mr. Bishop got. He got a response from the appellate prosecutor's office last night, PR person. And you see there in quotes right below the watch. I want to read that to you. The Attorney General's office moved the overtime case forward because you remember the overtime case where in September of last year, Ms. Thornley was charged with various counts of overtime fraud, etc. And so, but the Attorney General's office moved the case forward by referring allegations of theft and forgery to the state appellate prosecutor's office. And criminal charges are pending. Just as we referred the theft and forgery allegations, we have referred allegations that Ms. Thornley committed workman's compensation fraud to the appellate prosecutor's office. Our understanding is the matter is under review. So when I read this article, I was like, the Attorney General's office is saying to the people that we have referred this matter to the state appellate prosecutor. I'll tell you who they are in a second. And I got to thinking, the Attorney General is the chief legal officer of the state of Illinois. Why is he referring or saying he's referring anything to anybody? It doesn't even make any sense. So I called a friend of mine, called a couple friends of mine, because I admit that there's some things that I hear that don't make sense to me. I'm like, I got to call somebody that does this stuff because I'm confused. And so I called a couple of my friends that are involved in a lot of criminal work. And I said, have you ever heard of the Attorney General referring something to the appellate prosecutor? I've never heard of such a thing. And he said, in my 30-some years experience, I've never heard of that happening either. And so therein lies the conversation I want to have to you. The Attorney General's office suggesting that they referred not only the overtime fraud issue to the appellate prosecutor, but now this workman's comp issue to the appellate prosecutor. That's what I want to talk to you about. So the next document that I have for you that I want you to look at is 15 ILCS 205/4. This is a part of the law that lays out the mandatory duties of your Attorney General, what they will have to do is required by law, okay? So it's 15 ILCS 204/4. And I want to take you to subsection 5. Go down to number 5, Ryan. Just go down a little bit. There you go. Oh, you went way too far. There it is. Okay. See there, number 5, you guys? It says to investigate alleged violations of the statutes which the Attorney General has a duty to enforce. So he has a mandatory duty, the Attorney General's office, to investigate alleged violations of statutes which the Attorney General has a duty to enforce. And I'm going to get to it, but I'm going to let you know now, he has a duty under the law to investigate and prosecute violations of the Workmen's Compensation Act. So again, this is a mandatory duty placed on your Attorney General. Go to the next one, Ryan, which is section 3-9005. I piled on these documents on him in the last 15 minutes, guys, so give him a second as he pulls them up. This is the provision of the law that puts the what does your county state's attorney have to do? Because you guys are aware each of the counties that you live in, wherever you live, has a state's attorney who has certain obligations that they have to do. Your attorney general for the whole state has certain obligations that they have. Sometimes, many times they're separate, but sometimes they overlap. The county state's attorney has the obligation to commence and prosecute all actions, suits, indictments, and prosecutions, both civil and criminal being the important one here, in the circuit court for the county in which the people of the state or county may be concerned. So in Sangamon County, for example, your state's attorney is Dan Wright. Dan has an obligation to commence all civil and criminal actions in that county, okay? Go now to, Ryan, to 725 ILCS 210. So you now know who the state's attorney is and what he does. You know what the attorney general's obligations are, kind of. I want to tell you about the appellate prosecutor's office that Attorney General Raoul is referring to, okay? (725) ILCS 210/4. Yeah, we saw that one already. I'll read it to you while he's trying to find the document, guys. So this is the appellate prosecutor's office, okay? And Dusty pointed out up here about part of what they do, okay? So the appellate prosecutor's office, they assist the county state's attorneys. There it is. He found it, okay? So it says here, I want to make sure you understand this. The office, and when it refers to the office, it's talking about the appellate prosecutor. They may represent the people of the state on appeal in all cases under 3,000. So on appeal, this issue of Jenny Thornley is not an appeal issue. So that section doesn't apply. Go to Part B. Now on Part B, this is other instances when the appellate prosecutor's office can be involved with the county state's attorneys. And it says under these certain laws here, the office, appellate prosecutor, can assist in all kinds of laws, controlled substances, cannabis control, meth, things like that. None of those statutes apply in the Thornley case. They don't matter, okay? They don't matter. And then down below where it says, in addition to, the office may also assist state's attorneys in the discharge of their duties. Assist the state's attorneys in the discharge of their duties in trials, prosecution, etc., when requested to do so by the state's attorney. So if the state's attorney asks for assistance from the appellate prosecutor, they can help. Next thing is, in addition, the second circumstance is the office may act as special prosecutor. They may act as a special prosecutor on behalf of the state's attorney if appointed by the court. They have to be appointed by the court. To be effective, the order appointing the office as special prosecutor must identify the case and the subject matter, and that they serve at the pleasure of the attorney general. So what that means, you guys, is that if the county state's attorney wants a special prosecutor to get involved in a case, they have to file a motion and get an order from the judge appointing the appellate prosecutor as special prosecutor, because they're going to take that case over and they're going to operate that case. But it also says if the attorney general, who is the chief legal officer, wants to take over on behalf of the county state's attorney, they can do that if they want to. That's why they have to know about it. This statute that I just read to you is the only time that the appellate prosecutor gets involved in a case. You know what you didn't see in here is that the appellate prosecutor gets involved in cases because the Attorney General's office asked them to. I had to call my friends to make sure. I know I have not found any, and I'm willing to let them explain themselves if they want to where the Attorney General can delegate or go to the appellate prosecutor for anything. The county state's attorney has to go to them and has to, if they want them to be a special prosecutor and just not to help them, there has to be an order of the court. You with me? Go to number 5, where it's obtaining service from the Special Prosecution Unit. It's on the website, Ryan. So the appellate prosecutor's office has something on their website, because the appellate prosecutor's office, in my experience, they're very knowledgeable and very competent, and they do things the way they're supposed to do, as I understand it. So here, if you go to the appellate prosecutor's website, they have a special prosecution unit. And if you go down to the below, Ryan, where it talks about how you obtain their services, stop right there. You have to submit a request form. This would be the state's attorney's office, okay? And it says in here, please indicate on the form whether the appointment of a special prosecutor is being requested, just asking for assistance or review. In the case of the investigation requiring a special prosecutor, an order appointing the agency will be required, because I just read the law to you, okay? So the state appellate prosecutor says you need an order if you want us to be special prosecutor. If you just want us to investigate or require assistance, we don't need to have that court order. Makes sense too. They even give you links to a motion for appointment and an order of appointment on their website, okay? So if the state's attorney wants a special prosecutor, the court has to appoint them. Number 6 is the docket. From back in September 2021, Ms. Thornley was charged on the overtime allegations of fraud. She was charged with numerous counts. She was charged with 4 counts of forgery, 1 count of theft, and 2 accounts of official misconduct, you guys, okay? September 22nd, 2021, this case was filed. The very first day they were filed, it says that it was done by, go all the way to the top, Ryan. See where it says there, State of Illinois is the plaintiff, and it has the attorney box? The attorney box is empty. Typically, that would say Dan Wright is the state's attorney of Sangamon County or one of his assistants. It doesn't say anything. If you scroll down a little bit to where right there, see here where it starts listing all of the charges against Ms. Thornley. See where it says, go back down. It says Special Appellate Prosecutor. I see nowhere in the record to where a motion or appointment of the special prosecutor was authorized by the court. Again, it needs to be explained to somebody. Is it someplace I didn't see it? Is there some nuance where they think they don't need it? But this says there is no special prosecutor been appointed. That's the first thing to take from it. The next thing to take from it is that it would have had to have been Mr. Dan Wright, the state's attorney, who would have requested them to be appointed special prosecutor, not the Attorney General's office. Again, there's nothing in the law that I found that says the Attorney General can ask them to be appointed. I'm repeating myself. I want to make sure you understand. So where in this case has the order been entered saying, yes, you are now appointed special prosecutor? It's not in there. And again, the law I just read to you, and from calling my friends that do a lot of this work, says it has to be in there. Now, number 7, because I wanted to understand, I went and pulled a case from 2002. It's People v. Ward. This is a case in 2002. And if you go to page 4, Ryan, this case deals with the question that I'm raising right now. Okay? It's what I'm raising. Page 4, where it talks about analysis. Right there, bottom right. How come that thing moves so fast? Go down a little bit more. There it is, right there. Okay. We're going to address the trial court where it erred in allowing Mr. Zallar of the state's attorney appellate prosecutor office to prosecute the case. The defendant insists that they were prosecuted by an individual who was not authorized to prosecute the case. and that his conviction was void. We agree with the defendant. So in this case, the defendant, who was alleged and convicted of committing a crime, says that the appellate prosecutor wasn't properly appointed in the case. And if you go on to read this case, I'm not going to have Ryan scroll around with it on there, but what the court said is that while it's true that the trial court can permit the state's attorney to ask the appellate prosecutor to do the job, the record is void of any order appointing the special assistant. So there was no order in the case. And so since there was no order in the case was overturned. I don't see an order in this case. So that's a question. The bigger question is how does the Attorney General tell Mr. Bishop that we referred the case to the appellate prosecutor? Because I see nothing that says that they can do that. Now, as to the issue of the workman's comp fraud, we now have the Attorney General saying they've referred it to the appellate prosecutor, which is concerning. Now, before the state's attorney or the Attorney General gets a case regarding work comp fraud, it has to be investigated by the Department of Insurance. And the Department of Insurance, it appears, has investigated this case, as Mr. Bishop wrote, and has recommended that charges be considered. Otherwise, it would never make it to the state's attorney or to the Attorney General. So the mere fact that the Attorney General is talking about it suggests that there has been something from the Division of Insurance saying that there was fraud or alleged fraud. Why did the Attorney General even suggest they referred it out? Why wouldn't the Attorney General prosecute it himself? Are there people alleged to have committed some kind of fraud in their conspiracy or something that gave him pause? I don't know, but I want to go to the statute with you now where this issue of the alleged fraud of work comp exists. It's in the Workmen's Compensation Act. I want to read a few things to you, okay? Go to that, Ryan. It's 820 ILCS 305. This is the law of the workman's comp issue that we've been talking about. He's looking, I promise. It's the last one, Ryan. We went through all the rest of them. (820) ILCS 305/25.5. It's 3 pages long. While he's pulling it up, I'm going to read it. So again, this is the part of the workman's compensation statute that it's alleged that Ms. Thornley and maybe others have violated, okay? Because if, in fact, the Attorney General has seen something and referred it out, that would suggest that the Division of Insurance has completed their investigation. Because actually, Emily Fox from the Merit Board opened a complaint with the Division of Insurance fraud unit last year. Wouldn't have thought it would have taken that long, but we don't know when it was referred. I want to know when the Division of Insurance referred it out to the Attorney General or the state's attorney, and then I want to know when this supposed referral was made to the appellate prosecutor, even though I don't believe the appellate prosecutor can take referrals from the Attorney General's office. So Ryan must have went to sleep, guys. He says my internet's messing up. Hopefully it was a long time ago. The unlawful acts. This is what's unlawful in the workman's compensation, okay? It's unlawful for any person, company, corporation, insurance carrier. There's one. The insurance carriers can't do certain things either, okay? healthcare provider or other entity to do something. This is what they can't do. And I want to read you number 2. Intentionally make or cause to be made any false or fraudulent material statement or material representation for the purpose of obtaining or denying workman's comp. So if you're trying to get a workman's comp claim, you're a 501 employee, you can't make a false statement. Pretty straightforward, right? Guess what else is a problem? If anyone else intentionally assists, abets, solicits, or conspires with anyone to commit or write a false statement or to present a false work comp claim. So conspiracy to commit workman's comp claim is, you can be liable just like the person that submitted the work comp claim. Now, when it says make a false statement, what is considered a statement? Any writing, notice, proof of injury, etc. So the notice that Ms. Thornley filed on July 30th, 2020, listing the governor's office and the governor himself, was a false statement. She collected almost $70,000 of benefits, temporary disability benefits, the way we understand it, based upon that false statement. As we understand it, Ann Spillane from the governor's office helped her with that. Kevin Ritchie from CMS helped her with that. Scott Lerner from the governor's office may have helped with that. Just from the emails is all I'm looking at. Some guy named Micah from TriStar was involved in that, because he's the one, Micah's the one that told him, I can only talk to the governor's office. I can't talk to you at Merit Board. So all of those people were involved. What's the violation? If it's over 10 but less than $100,000, it's a Class 2 felony in the state of Illinois. Class 2 felony, 3 to 7. The law also says that the fraud unit, the Division of Insurance Fraud Unit, has to investigate these when they're submitted to them by people. And if they believe it's necessary, the fraud unit, they refer for charges to 2 people: the state's attorney or the attorney general. Remember when I told you the attorney general has a mandatory duty to prosecute crimes as required by statute? This statute, the Workman's Comp Act, places that duty on the attorney general to prosecute work comp claim, fraud claims. It also concurrently places it with the state's attorney. And the state's attorney could, under the right circumstances, bring a claim, a charge, and then ask the court to appoint the special prosecutor from the state appellate prosecutor's office, and the judge could allow that. It's perfectly appropriate. That's the process in a nutshell. But yet we have now the Attorney General's office public relations person saying that not only did they refer the overtime charge to the appellate prosecutor, they referred the work comp to the appellate prosecutor. Those things don't make any sense to me or to my friends that have a lot more experience in this arena than I do. They don't. The case that's existing since last September, I don't see an order in there authorizing the special prosecutor from the state appellate prosecutor. And I'm assuming that Dan Wright's the one that asked them to intervene in that case, because the statute says that he can do that. So we got to figure this out. Where is this work comp claim sitting? Mr. Bishop's on to something with his questions. They need to let us know, when did something get referred from the Division of Insurance to Mr. Wright and to the Attorney General? What does this mean? They've referred it to the appellate prosecutor. Doesn't make any sense procedurally or legally or politically. Why is the Attorney General saying he's referred it out? What would he refer it out to? If there's a crime, he needs to prosecute it, because there's a duty on him under the law to prosecute that crime. Whoever's involved, he needs to do it. So that's the explanation that I wanted to give you guys. I hope that helps. There's a lot more questions that need to be answered now that the Attorney General's office has chimed in and tried to make a statement, because that statement, again, it creates a whole lot more questions than it answered. So thank you very much.